Okay. Good morning. And if you call the first case.
SJC-13103, Commonwealth v. Earl, Garner.
Attorney Mark.
May it please the court, David Mark of the Commonwealth. In versus Torres Pagan, this court clarified and reaffirmed the requirement that in order to make a pat frisk for officer safety, two prongs must be met. Both that the officer have a reasonable suspicion that the suspect is armed, and that he have a reasonable suspicion that the suspect presents a danger to the stopping officer.
Attorney Mark, before you get over here, before you get involved into detail in your introduction, can you address first the issue of the factual findings by the judge and the argument that the appeals court found facts and that's where they went wrong?
So it's a bit of an awkward question, Your Honor, because I'm not here to defend the appeals court's opinion, which I think in a couple of respects may sort of assume what needs to be proved.
Okay.
Well, then let's just do it in detail. The Judge McGuire says 2 or 3 steps back, and do we put blading into the factual predicate in order to apply to Torres Pagan? And also, we've got the fright or flight, and do we put that into the factual predicate, considering Judge McGuire's testimony that he's not credited anything about the defendant's thoughts?
Let me take those in order. I think blading is a red herring in this case. It's true that the officer used the word once. I think all it meant in this instance was that that Mr. Garner was moving diagonally away from the car and the officers. I don't think it was invoked as a term of art or to suggest any evasive.
Well, then do you concede that it doesn't add anything to the
Absolutely. Yes, Your Honor.
equation, because he was circled by police officers?
I don't think blading has anything, beyond the fact that it's a word that describes this diagonal movement.
Well, thank you, Mr. Mark. Let's just take one more step into it then, if we could, please. Do you also agree that his steps backwards don't add anything to the factual predicate, since there's no part of his body that he was trying to hide from the troopers?
Oh, no, I disagree strongly.
All right, tell me.
Both of the testifying troopers testified that the defendant, when he got out, continued to move backwards away from the car and the officers, and they formed at that moment the very strong impression that he was on the point of flight. I think that his movement there is central to our case, that reasonable suspicion was made out here.
Okay, I get that. Whether that's how it works out or not, I get that. But I'm asking about moving backwards as it adds to whether or not, you referenced Torres Pagan, whether or not he's armed. You've got a conviction, 6 years old. You've got, well, you're going to get to flight or fight. Yep. And then you have these steps backwards that you're making a point that they go toward perhaps flight. Maybe it does. But how does that add to whether he's armed?
Are you asking, Your Honor, whether the fact that he's moving backwards as opposed to getting out and moving forwards has significance?
I'm asking what the officer called blading. I agree it's a red herring and it's not blading anyway. Whether his movement backwards adds anything to whether or not he's armed.
I may not be understanding your question, because my answer would be the same, that the movement backwards is what they understood as a precursor to flight. And that, so the significance of that is that they were authorized to detain him until the conclusion of the stop.
I understand the whole argument about the duration that's in the amicus brief and in your reply. I'm evidently not asking the question well. You have to be able to demonstrate reasonable suspicion that he's armed. Does the steps backwards add anything to that?
To armed as opposed to dangerous?
That's what I'm asking.
Okay, sorry. I beg your pardon for being obtuse. I think the answer to that is no.
Okay.
They go to dangerous, they do not go to harm. Well, so there's this. The fact that but it's not really directly there. The fact that so the officer's inference is, we arrive on the scene. Here's a man we've known, Dunderdale has stopped him before, no problem. Now he's exceedingly nervous. So their minds, they're officers, but it goes right to contraband. What kind of contraband does this man carry? Well, he's been twice convicted of carrying a firearm.
How long ago was that?
The most recent conviction was 6 years before the stop. He served 3 years on that conviction. So he was released in 2014. The stop is in 2017. But once he invites them to search the car, the possibility that his distress is related to his carrying contraband is now more reasonably limited to his person than it is to anything related to the car or other possible aspects. So in an indirect way, the movement away from the car sort of confirms that if there's a problem here and the problem is he's carrying a gun, then it's on his person, it's not in the car.
You also said, you said that stepping back meant dangerous as well?
Well, the argument is this: if they're entitled to detain him at the scene, and I contend that they are, and he's now on the point of flight, and they believe him to be armed, there is now some possibility there's going to be a wrestling match with a man they think may have a pistol concealed on his person. That is not a situation the officers want to be in. And they foreclosed that possibility by grabbing him and pat frisking him before he fled or had an opportunity to flee.
So his offer to allow the officers to search the car makes it reasonable to assume that he's armed? Is that your argument?
No, it simply eliminates, I think that the thought that he was armed occurred to the officers almost immediately, given his past history and his now unexplained extreme nervousness.
Because 6 years ago, he had a firearm offense?
Two, it's a second offense.
Yes, 6 years ago, though.
And the officers, concerned as they reasonably were for their safety, the fact that it's 6 years ago has some attenuating effect, but not to the point where it's irrelevant to the reasonable suspicion calculus.
Isn't the problem, though, it's assuming, for the sake of my question, that everything you're saying about dangerous is correct. It doesn't matter how far you are able to address dangerousness if you can't show the firearm. And we've got three things going on here. I know you haven't even gotten to the second one yet. You got an old conviction. The second one is obviously even more than 6 years. You've got the 2 or 3 steps backwards, and you've got the fight or flight. Giving you all the inferences that you want on dangerousness, how are you getting to arm?
You're leaving out an essential part of this equation from our point of view, and that is his anomalous behavior.
Is it anomalous? On the second time he was stopped, he was nervous too.
No, on the second time he was stopped, he was angry. Here, and if he had that reaction, I think we would have less to argue here, but he's not angry.
But
He's
we
clearly-
can't base everything on his variable moods, can we?
Well, not everything, but I'm not asking you to do that. What I'm suggesting to you is, and variable moods kind of trivializes what the officers were looking at here. They know him to have been twice convicted for a gun offense. Now they had a previous, this officer Dunderdale had previous experiences with him where everything was fine on a stop, and now suddenly it's not fine. And
But I think you're assuming that everything had been fine in the prior 3 stops. There was one time where he was angry, and then there was a second time where the officer tried to convert him into a CI, and now he's nervous, or at least shaking his leg.
So I think there's a difference between on the first stop after his release from prison. He stopped about a week later, according to the testimony, and his initial reaction was anger. You're out to get me, because it was Dunderdale, the same person who had stopped him for the offense that ultimately resulted in his conviction and his going to prison.
Right.
But as Dunderdale relates, he arrested him, and then the defendant's behavior changed on the way to the station. They had what he describes as a good conversation. And then, so that's how that stop ended. He ended up stopping him twice more. Everything was fine. There was, Dunderdale's phrase is they had a good rapport, but I take it, all that means is they had a good, cordial, non-confrontational conversation. In both of those instances, he's released without citation, even though in one of them he was driving on a suspended license. The judge credited the testimony of the defendant's fiance that in one of those stops, Dunderdale asked for, if you hear anything, could you let us know? I don't know that somehow detracts from our contention that these previous stops were, suggested to a kind of baseline of interaction with this man, that now we were seeing something very, very different. The officers were seeing something very, very different. And it was reasonable for them to be concerned about why that was so. It is not a great leap, although there are certainly other explanations, but it is not a great leap to draw the inference that his evident distress was related to the fact that he's now being stopped by officers and he has contraband on his person. And as I said, the contraband he's known to carry is a firearm. Your Honor.
So does it always work to the law enforcement's benefit about the prior interactions with an individual, one way or the other? Let me just change the circumstance for you. Let's just say, for instance, you were telling me that the prior instances with the defendant, and we've had cases like this, I believe, where there was anger, or there was nervousness, or there was some other emotional response. But this time, there's nothing but cooperation and compliance. And now, in this calculus, the Commonwealth could argue, well, Judge, these prior instances, he was angry, he was belligerent, he was nervous, but this time he was calm. So now law enforcement gets to use that. Now the calmness they get to use to say something's not right, because previously he was upset and he was angry. Is there ever a point where that's never going to be something that law enforcement can always use as a sword or a shield?
Yes, I think your example is a good one of where it would be inappropriate for an officer to draw an inference from a suspect's detainee's calm demeanor under the circumstances, even if there'd been a prior history. The fact that the interactions are moving in the direction of being less confrontational is not a basis for a search or a concern about officer safety.
Okay, thank you.
The concern here really relates to the fact that, and this is why I expended so much energy on this in our brief and in the reply brief. The officers think it is very likely this man is going to flee, and therefore it is very likely that if they allow that, there's going to be a wrestling match. That is really bad if he has a gun.
Should we talk then perhaps about the basis for that? Because when you sit down, we're going to hear that the factual finding that anything the police officer speculated about the defendant's thoughts isn't credited. And so what I would ask you is, first of all, is there enough to draw the inference fight or flight? And is that inference being drawn completely from observation and not from what the defendant's thoughts might be?
Despite what the motion judge said, my reading of this testimony is that the officers were testifying to behavior that in their training and experience precedes flight. They were not speculating about what he was thinking. They didn't care what he was thinking. They only cared that they were seeing behavior that in their experience would lead to him leaving the scene. So, and I contend that to the extent that the judge, the motion judge, discounted that entirely, that was error.
How do we separate that, Mr. Mark? Because Judge McGuire says to the extent that they suppose something about his mental state, I'm not going to credit it, but physical observations are in play here, correct? That's the ground rules we have.
If I understood your question, I'm having trouble hearing you.
Yeah. Judge McGuire, my memory says in his decision, to the extent the police speculate about his mental state,
Right, his
it-
thoughts,
that's out.
right,
But observations he credits, correct?
right.
Okay,
And
so
then he
those
says-
those are parameters.
Then he goes on to essentially say, as to fight or flight, they thought he was going to flee, so it doesn't matter. And in any event, the basis for that is what I described above, and it adds nothing. He gives it zero weight. And that,
So that you got to my question. So what I'm trying to ask you isn't that a supposition about his mental state that he's about to flee when his eyes dart and he kind of walks backwards?
Your Honor, to the extent that is true, it is absolutely essential that police officers do that.
I know, but I get that.
Okay.
But the question I have is more basic.
I really.
Is your argument, and I get your argument about the right to detain, and we're gonna have a wrestling match, and we should know whether or not someone has a knife or a gun before we wrestle with them. But is that finding foreclosed by McGuire's disbelief or discrediting of the officer's take on the defendant's mental state?
I don't know whether I'm answering your question correctly, but I would say that he just entirely missed the point in saying that the testimony related to guessing what the defendant was thinking. That isn't what they were about. They're looking at behavior and recognizing it as behavior that precedes other behavior that they would be concerned about. That's all. There's no mind reading involved in that.
Okay, thank you.
Thank you very much, Sean.
Thank you. Okay, Mr. Kelly.
Morning. May it please the court, Brian Kelly on behalf of Mr. Garner.
Mr. Kelly, could you just address the last point I asked? If we find that there was proper evidence that your client was about to flee, do you believe that the police have a right to pat for someone before they get into a wrestling match?
I think I should answer that question by saying I think the case law suggests no. The answer is no. Because as I understood Judge McGuire's decision, it was based on a finding that he didn't really believe that there was an opportunity for him to flee. But if you look at his findings of fact, Your Honor, it's one of the first things he says about this fight or flight question was, it doesn't add a lot to the analysis here. One, because we're talking about potential flight. And then two, there were no real facts. At least
And I should change, and I obviously need to qualify my question, because if there's no hint at all that someone's armed, then the pure someone trying to flee before the wrestling match, they don't have a right unless they're armed. But here, you're relying on Judge McGuire's finding, correct?
I am. And I think the other thing I would say about that is, wouldn't that undercut the court's ruling on Torres Pagan, which is we need some reasonable suspicion to believe the defendant is presently armed and dangerous.
Right, right. I mean, and that would be part of the calculus that they're going to get into this. No, I get you, Mr. Kelly.
And I think if it were true that if we were having a motion to suppress and a judge could just say, well, I thought he was going to leave, then I think it would undercut this court's ruling on Torres Pagan. It would serve to undercut what I think was the basis of Torres Pagan, which was going back to the standard that was enunciated during that particular case.
Thank you, Mr.
So-
Kelly. You answered my question.
Thank you.
Could I follow up one more question on that? So the Commonwealth argues at one point that the judge discredits their speculation about what he's going to do, but they seem to argue, the Commonwealth is arguing that, and again, I think it's the same variation of what Justice Gaziano is asking, that that doesn't eliminate the officer's suspicions, meaning he may their comment that he's about to flee has no independent significance, except for that still preserves the officer's ability to think he's about to flee. Do you think the judge foreclosed that latter part?
I certainly wish that the comment about his thoughts was a little more robust, because I
Right.
think it's so broad, right?
Hmm.
I mean, everything that he's thinking.
Right.
So that's a lot, right? I mean, because nervousness is what you're thinking. Shaking is what you're thinking. So it's an awfully broad, I understand the question, but I think it forecloses this notion that I think my biggest thing about this is we had a hearing, right? We're in the middle of this courtroom. I'm standing there and I'm walking through with Trooper Dunderdale where he is in this street, where he's standing. I'm using the photograph and can't see that on a transcript. You can't, it's hard to recreate that. And I think that's why we accord such deference to lower courts, because we're not there. You're not there. The appellate courts are not there.
Well,
And-
that's really a great point, and it's difficult for us right now as well, because we accept the subsidiary findings, but we can draw our own overall conclusions from that.
Sure.
But on the other hand, we accept the judge's characterization of the evidence, and I'm also having a difficult time figuring out where Judge McGuire's comments about the fight or flight fit into how we review the record to determine what our factual predicate is to apply to Torres-Pagan.
And I think the answer to that is if you look a little bit at the transcript, and I think the transcript is before the court, you can see where we're having this discussion about fight or flight. And I didn't honestly object to it because I just didn't see any real basis for it. And basically the testimony was, well, I had a couple courses and on, fight or flight, how to recognize fight or flight. But what was the basis of that? That he's nervous and that he looked over his shoulder. Well, I think that was rebutted by the judge's findings that Trooper Ledeen was standing behind him and said something to the effect of, Earl, why don't you come on over here? So the factual underpinning of fight or flight, at least from the judge's perspective, was really not there. And I think that's why, and as much as he didn't say, and I would have liked him to say, I don't find this credible, instead he just said, it doesn't add to the analysis, which I think is part and parcel to, I just don't think this is adding to the analysis here. So
You said he looked over his shoulder and he was nervous, but what about the stepping back part?
So, and that was the other thing about the photograph that I thought was important, because the judge had, I think there was in a footnote that he said he couldn't have gone very far. And so the testimony essentially is Mr. Garner steps out of the vehicle and there's some huge, I think, confusion language about where he's standing, but it's my understanding that Trooper Ledeen is standing behind him. Trooper Dunderdale is to his left. The door's like here, right? So it's, and so, as I understood Judge McGuire's findings was he couldn't have backed up very far because it's a dead end road. He stops the vehicle in the middle of the road and he's surrounded by 3 armed state police officers. So that I think is really important from the perspective of how he viewed that space and what we're talking about, which I think is a really important fact in this case.
Well, that's I think one of the reasons you cite to Commonwealth versus Isaiah is because, as I understand it, we defer to the factual deduction.
That's right.
Of the judge. And I also recognize more precision would have been helpful, but you're saying these are factual deductions from the evidence, aren't you?
Yes, yes. And I think, in the cases where the court has a record, let's say there's a statement or, the question is voluntariness, you have that statement before you. You can listen to it. If it's audio and video recorded, you don't have that here. And so in those cases, I think the case law is There's not a ton of deference because the court can listen to the responses and make your own assessment. You don't have that before. You have testimony, you have a photograph, and there's testimony about where, and then findings of fact, which are traditionally accorded a lot of deference. And so that's what I'm really asking the court to do here, is to do the same thing that this court has traditionally done, which is the lower court heard the evidence. It heard the officer's testimony. It listened to the officer's testimony. It assessed the credibility, although he doesn't necessarily say in his findings of fact, I don't find this credible, but he weighs it in a way that I think is important to give deference to. And in that particular space where Mr. Garner is and how he's acting, those are all really important facts for the court to assess as he's listening to the officers, he's listening to the troopers. And I think he does that in this particular case. And as he puts those two things together, that is what the Commonwealth is relying on mostly is this prior conviction, which is 6 years old, and then his marked nervousness. We know that people don't always, a lot of people are nervous for many reasons when they're confronted with law enforcement questions. And he's out of the vehicle.
Mr. Kelly, where does that square with what the appeals court wrote in that the police can consider odd behavior? Does that make it odd behavior when someone acts differently than they did in a prior stop? Or how do we take this odd behavior line in the case law?
I think there's a multitude of factors that you could consider. One, he stopped, there's 3 armed police officers around him. He's an African-American man. He's had 4 previous encounters with the same officer. Now,
But I guess the question I have is, and I get your argument, but what does odd behavior mean to you?
Is nervousness odd? Sure, I guess. I mean, but I don't think it's odd because a person's being stopped by the police. So
I think everybody's, well, most people are nervous when they're stopped by the police.
right. And I don't know, I thought the appeals court's decision had really conflicted with the judge's findings of fact. And I'm not here to dispute what the appeals court did so much as I want the court to uphold what Judge McGuire did. So I'm not, my argument here today is.
And one last question about the appeals court decision, Ms. Kelly. Do you concede that the police had the right to detain? I know they didn't have a right, your position to Petrus. Do you concede they had a right to detain your client until they finished the citation process?
So that particular argument, I think, from my perspective, was waived because it wasn't argued below. But the question, I think, is how long can they, I think what Your Honor is asking, how long can they detain somebody?
Well, we know the answer to that from Cordero until they have the right, until they complete the process.
Right.
But do you concede they had a right to detain him at least?
I don't. And the reason I don't is because.
So they're
this
supposed
goes
to
back
just, they can let him go?
Well,
So he can just beat feet and they say, oh,
see, if that was the thrust of the motion, and if that was the defense, that was the Commonwealth's argument, I would have been able to ask questions about that, right? And that wasn't really the thrust of the particular motion we were doing. They gave him a ticket, but my understanding is they gave him a warning.
but
Right.
that's completing the process. So
Right.
I guess you don't want to answer my question. I don't want to try to goad you into a concession you don't want to make.
It's not so much that, Your Honor. It depends on the case, right? If from my perspective going in, and I think you got this from the flavor of the hearing, I thought it was pretextual. That was the argument we were making at the time Buckley was under advisement. And Judge McGuire issued an opinion based on the Pat Frisk. So from my perspective, I thought it was a pretextual. My argument was it was pretextual, and that the whole reason that they were keeping him there was to just root around. And the problem with this idea that you can elongate a stop and just hold somebody there, to write the ticket at the end, is that it lends to this idea that they're just elongating the stop to. So I think if it was a true stop, yes, the answer is correct. Yes, they can do that. But if it's for other reasons, and that's why, and I'm not trying to avoid the question, I think it was not really. It was not really the thrust of that particular motion at the
No,
time.
I get it. You've answered my questions. So.
Thank you. I think with that, I have some more time, but unless there's any other questions, I'm just going to rest on the brief that we have.
Okay, thank you.
Thank you.